Just a quick one on the right to manage legislation. You just said obviously it's fairly new, it's only 12 years old. Is there anything being proposed at the moment to reform that legislation? The reason why I ask that is because we've been down that route twice, and I believe that it's very heavily weighted towards the management companies and the landlords against the wishes of the leaseholders. And it is, we've been through it twice and lost, and if the management company or the freeholder employs, sophisticated lawyers and stuff, there are millions of loopholes in that, and they can get out of it. And with that being the case, leaseholders can end up with large legal bills as well. So I was just wondering, is there anything coming up? Is anybody suggesting that this does need reforming?
There are suggestions. I mean, there are a number of bodies, people like Armour, who constantly lobby government for varying reforms to the leasehold sector as a whole. One of those in particular is regulation for managing agents, which has been pushed very heavily over recent years. And I think the short answer is that no, there is nothing on the horizon that says that as legislation that is going to be altered by government. However, it will be reformed as legal precedents are set by some of the greyer areas being going through the courts or the tribunal systems, and decisions being made which then have an influence on lower down the judicial system, your first tier tribunals and those sorts of places. And they will eventually get to a stage where in a certain situation a certain outcome will always be made because it's been made in a high court at some point. But in terms of reforming that legislation in any major way, I'm not aware of any serious movement to do that. There is pressure being applied, but
can I just jump in there? Jane, would you feel that it's a really difficult route to follow the right to manage? And that
I think it's really easy.
Yeah.
I know it's not easy, and I know where you are. You've had various problems with it. What I would say with right to manage is it works really well in small, flat developments where everybody who owns the flat lives there. In that situation, in my experience, it works really, really well because you've maybe only got half a dozen people involved. You've probably got a landlord who thought they wanted to retain the management of the property when they did the development. They've lost interest a bit. They're finding all the statutory obligations on them a bit of a burden. It's not really making them any money when they thought retaining the management might make them a bit of money. And in that situation, they're fairly happy without opposing to let it go. They usually say that they like to be a member of the right to manage company, which they're perfectly entitled to be, because they've still got the freehold, so they still have an interest in ensuring that you are managing the property properly. I think it's where we've had problems is where people have approached right to manage to try and deal with other issues. So, for example, if you have a development where actually your problem is to do with defects in the original development, right to manage isn't going to solve your problems at all. If you've had problems where you felt that the freeholder has been overcharging or not delivering on service charges, that won't resolve any of your historic problems. Your remedy there is to go to the first tier property tribunal and say they've been collecting service charge they shouldn't. But it does offer you a chance for a clean slate. It offers you a chance to say, that's what happened in the past. If the landlord lets it go through without any problem, it's not very expensive to do, relatively speaking. If you never have to make an application to the first tier property tribunal, you find your own managing agents. If you're very fortunate, your landlord serves all the counter notices they're supposed to, you find out what the contracts are, you can terminate existing contracts, get new people in, get new managing agents. you've got a clean slate to start going forward. But it doesn't work if you've got houses in your development, because houses don't have a right to manage. So, for example, Armstrong Key is a mixture of houses and flats. You have to work out what your block is, because you have to make an application for one block. So it's very difficult where you've got linked buildings, as Chris was talking about. You know, if you are trying to work out which building yours is, or you've got shared facilities, and
you mentioned blocks. Where you've got separate blocks, do they have to have a separate right to manage for each one, or can you put them all together?
No, you've got to have a separate one for each one.
Separate for each
There
one?
is some
Yes,
precedent set now,
yes,
that this is another grey area which there has been some recent case law, and it has actually successfully been achieved for a multi-block site under one company, by ensuring that every one of those blocks had more than 50% of participating people, and the judge used words to the effect of, actually it makes complete sense for that to be under one company rather than 6 different companies. And so, but that perhaps is a slightly common sense decision rather than to the letter of the law.
was it first tier?
I think it was higher tribunal, upper tribunal,
It
but
has
so
established a precedent.
so it would for first tier tribunals, but it wouldn't with any court proceedings.
But it was quite specific on the facts, and I think they were aiming to achieve that result on the facts, weren't they?
Yeah.
So you might find that other cases could be distinguished on their facts.
I think it makes a lot of sense if every block has achieved what it could have achieved individually anyway, but wants to do it all together. It seems like it's very soon. How would you want to come back?
I'd just like to say that, I agree the right to manage process is very easy in sort of smaller developments and smaller units. Not a problem, it'd be quite easy. The big problem for us, we have 176 apartments. There are 11 separate blocks, if you like. Whether they should be or not is debatable. The big problem is the percentage of owner-occupied. That is the big problem. And that is the thing which I would like addressed for this bill to be reformed. The 50% of tenants should be tenants, as in whether you're an owner, an occupier, or a tenant. It should be just that, but it isn't. It is owners.
Yes.
So if you've got people, in my own development, there's about, roughly it splits about 50-50. So in that situation, you've got 50% of the people that don't live there, have never lived there, have no idea what goes on there, but they're quite willing to sort of pay because they're told to pay the service charge. Whether they're getting value for money for that or not is immaterial to them. They don't care because they're covering it with the people that are renting off them. So they're not bothered. So that is the real key thing. If that was changed to not 50% of owners, but 50% of the people that live there, it'd be far easier for everybody to obtain the right to manage. What you also people need to be aware of before going down this route, because it's a bit of experience from ourselves, if the management company you're trying to get rid of or whatever really wants to hang on to that, this legislation is so full of holes and loopholes that they really want it, and they can afford, which they will be able to appoint some of the top solicitors in the land on these sort of issues. They will get out of it, and it can end up costing you a lot of money. It could end up you having to pay sort of their legal fees.
Well, you have to pay the other side's fees.
Correct.
That's the point.
My advice, having been through this situation twice, would be this is a sort of last resort. I wouldn't go down this route first. I would look at all other options before this route. In my experience, your buildings may well be different, might be easier.
No, I think I would always say that, and I think what I would also always say is you have to be aware that you have to pay the landlord's reasonable legal fees.
Who becomes liable for the landlord's legal fees if you haven't set a company up yet? Who's actually liable?
The right to manage company would be liable, and that would be the members of the right to manage company. If you were coming to us, we would say you need to, behind this application, have what we would call a participation agreement. That means all the people who wanted to participate, there would then be a binding agreement between them, so that they would all know what their potential
They
liabilities
become
are.
personally liable.
Yeah.
Just to sort of briefly explain the process slightly, when you go through the right to manage process, it is the right to manage company that serves the notices and acquires the right to manage. So you have to set the company up as the very first thing you do before you ever issue any notices, and therefore it is the company that takes all of that responsibility and obligation rather than any individual. I think just going on to some of your comment, I would agree entirely that right to manage probably is the last resort, but at the same time I would say don't give up hope. We, at the end of this month, are taking on the management of a development which is 288 apartments that's gone through right to manage, and they've done that with 80% of the owners of the properties living overseas. But it's been, there's no way not to underestimate that as a feat, but it's possible, and it costs money to do that because you have to search for where all of these owners live and actually get to the bottom of all that, and then go through the process and, as you say, potentially incur some legal costs. But actually, with larger developments, if every one of those developments puts 100 quid in to do it, then you've got quite a lot of money there. Every one of those people participating, not developments, puts some money in. You soon get quite a lot of money to address some of those matters.
Can you clarify that the point with the right to manage company, the company will be liable for the legal fees, and will that almost always be the case, that it will go back to the members of the company?
Right. On the legal fees, there is it's set out in the statutory legislation that you are responsible for the landlord's legal costs. The right to manage. So the first step before you approach the landlord is you get together, you set up the company, then you invite participation in the company. That's the next legal step. Those people who wish to be involved then become members of the company. At that stage, you've got to have 50% to take it further. And at that stage, you need to make sure that everybody who's going to participate will understand, because you've got the initial cost of setting up the company, and it's not quite the same as just buying any old off-the-shelf company. It's a prescribed form of company, so it costs a little bit more to buy. You still buy it off the shelf, but it costs a little bit more than just any old company that you might buy for £75 or something. I think it's about £345. Something like that is what we pay the company agents for a right to manage company. And at that stage, you need to probably go to everybody who said, we want to participate and we want a fighting fund, because once the notice is served on the landlord, if the landlord instructs solicitors to deal with it, then those solicitors are going to write to you or your solicitors to check that they're going to get their fees, to make sure that you know that you're going to get their fees paid. If they are using a solicitor, they may ask the solicitor acting for you to give what's called an undertaking for their fees. Your solicitor, the right to manage company solicitor, may decline to do that and may say you must rely on the statutory obligation to pay the fees, or they may say you've got to go to your participants, collect a pot of money, and then they give an undertaking and say we'll pay the fees up to X. Once you start going to court, it becomes much more difficult.
So that statutory obligation, where does that fall? Is that
on the right to manage company. So there is the element of the right to manage company has limited liability.
I'm trying to get a problem with whether the residents, the freeholders, the leaseholders of the apartments can
only the participating residents would have the liability.
And that's why you need a participation agreement.
Yes.
That's a legally binding document. Can I just jump in? There is a document for a lease which you can access, but there's also much I got out this morning, but I didn't bring it, called a participation agreement, helping you through that process. I want to come back to, is that what, I don't think that's the process that was followed the first two occasions. At Waterloo Quay. That there was a company set up, then a participation agreement signed. There's only two people in it.
But we had a company that we were looking to take over the management. Initially, we just wanted to get rid of Region because they're so bad. And they had an in-house solicitor that said, look, the right to manage legislation, if you do it right, it's okay, it will go through. So we had every confidence in them being able to do that. What I need to, people need to understand is, I've been around my development several times asking for signatures, and I've also found out where the owners are, contacted them by letter and stuff. It's a no-brainer decision. Look, if you will sign this thing, it's not even going to cost you anything. You're likely to have the management company change. Your service charge is probably going to come down. The services are going to vastly improve. Even with that cast iron sort of information, it's definitely going to happen. With no charges whatsoever, people will not sign up. So if you're going to these people and also asking them for money, with also the possibility that you're liable for legal expenses in the future, so you don't know how much you're asking them for, you've got no chance. So this legislation, I mean, believe me, it's from experience. I've been round all 176 blocks 3-4 times.
Yeah, I think that is the problem is that you've got people who don't live there. And Jerry and I were talking about this before we started. You have a massive problem when you have people who don't live there, because their interest in the property is that they're receiving an income stream from their rent. And in calculating what their income stream is, they look at what the outgoings are going to be in respect to the property, and they aren't really bothered about the level of services. If you live there, it's entirely different.
Just to back that point up, obviously the owner-occupiers, we probably get, I don't know, 70% of them all signing up because they know the problems. It is the other people that you just cannot get to sign up. But with all due respect as well, there are probably not many developments around that have a management company that have a percentage of owner-occupiers that's more than 60%, which just makes it...
Yeah, Albert Dock. Yeah, but they have their own problems.
But most of them now have got a high buy-to-let occupancy.
Thomas?